Okay, hi, and welcome to our Corporate Synergies pre-election compliance briefing. I'm Dan Kuperstein, SVP of the Compliance Consulting Team here at Corporate Synergies. And just as some quick background on me, I'm Marissa, an employee benefits attorney. I enjoy helping our clients develop strategies for reducing exposure to risks and liabilities, which is a big focus of what we'll be doing today. And I'm very lucky and happy to have with me here today the senior associate on our consulting team, Dorothy Summers. Dot has over 20 years of experience advising clients in all matters involving health and welfare plan compliance and other related regulatory matters, including experience working in government at CMS and seeing firsthand how government policy proposals are implemented in real life. And so I'm really happy she's here. She'll be joining me for our Q&A session at the end. And I'm looking forward to that. And so let's go ahead and dive in. And so for a quick overview today, we're going to be talking about two main topics. First, what are some of the major benefits-related regulatory changes and challenges that HR and benefits teams are experiencing right now as we head into this busy election season? And then we'll be talking about the main healthcare policy platforms and goals and initiatives of the two presidential candidates in this election, and what that's likely to mean for your organization's health and welfare plans and insurance arrangements. So we'll be talking about some of those implications and takeaways there. Okay, so let's start with that first topic. Some of the things that we're noticing are the major issues, trends, things that are happening, and I think you could probably categorize all of these things into what you might call COVID-19 conundrums. Basically, there's really three big areas that we're seeing that are big issues, and we're going to go through these things pretty quickly because the details are in all of our e-alerts and publications on these topics, which are available online. Those topics are one, handling the benefit plan implications of leaves and furloughs, especially with regard to the confusion that often arises regarding the ACA measurement period rules and the COBRA rules and how they work together, as well as confusion about the constantly changing rules and guidance under the FFCRA, and about the impact of all of those new expanded state and local paid leave and paid sick leave rules, as well as the many state and local COVID-19 related rules, which when you add all of that together, it can be just voluminous, really, right, for any HR benefits team out there. And then the second big topic is handling the cafeteria plan impacts of the COVID-19, especially with regard to DCAPs. And the third would be probably we're seeing as a big thing now is handling those MLR rebates and the related ERISA fiduciary issues. So I'm going to try to talk briefly about each of those things as quick as I can here. I think with the first one, really one big area that's causing a lot of confusion across the country that's not necessarily specific to any particular region dealing with a particular paid sick leave or paid FMLA issue is the FFCRA, which the Families First Coronavirus Response Act enacted these new emergency paid sick leave and emergency family and medical leave provisions for organizations that have fewer than 500 employees. They were difficult to understand initially when they came out in April. The law was enacted in April. Right shortly thereafter, regulations came out, as well as FAQ guidance. And then over the summer, in August, a federal district court in the Southern District of New York basically said, no, the DOL really went too far in many of these rules, and we're going to invalidate them. So several of those major provisions of the FFCRA were then invalidated by that Southern District of New York federal district court decision in August. And unfortunately, they didn't give us any clarity on the geographic scope of that decision. So, best case scenario only applies to those jurisdictions, those counties in New York that are part of the Southern District of New York. But it was a little confusing as to what the impact of that decision would be. And then subsequently, more recently, the DOL issued revised regulations disagreeing with the district court on most things, but agreeing to make two changes. One, narrowing the definition of who is an exempt healthcare worker, and which means that there's less people out there who could be called exempt and not allowed to take the FFCRA leaves. And then secondly, they relaxed the advanced notification requirements. And so that being said, while that was probably, a step away from that decision, right? If you're an employer operating in the Southern District of New York, which is a select group of New York counties in the New York City metro region, then the safest way to stay in compliance is if you're one of those employers in that New York City metro region to follow the rules of that federal district court decision when it comes to FFCRA leave, rather than the DOL's most recent revised rules. And you can read much more about this and those two changes in our September 17th e-alert on this topic, which is available on the Corporate Synergies Health and Welfare Compliance, or HAWC forum page, HAWC HAWC, and that's on LinkedIn. And we will be providing a link in the chat to that webpage. And from there, you can also find several of our other recent e-alerts on this topic, and the new paid sick leave law in New York and other leave and benefits related e-alerts. So definitely check those out. Okay, let's talk about the cafeteria plan impact very quickly. Two main areas still causing COVID-19 related conundrums are plan administration questions about how to implement the different types of optional plan relief for cafeteria plans that was provided by the IRS at the discretion of employers. So employers have the option of doing those things if they want to. We did an e-alert on May 15th on that topic. And also, we're seeing much more recently issues where companies are not passing their dependent care assistance plan, or DCAP, non-discrimination testing because people are just not utilizing. There's a lot of plans out there that are failing this non-discrimination testing because those non-discrimination tests are based on plan utilization. In fact, there's a non-discrimination test called the 55% utilization test that's part of that non-discrimination testing. And what we're seeing is that less non-highly compensated people are contributing to these, resulting in failures of the non-discrimination testing. And that can be problematic if your organization tries to fix the problem after the end of the 2020 calendar year. Of course, because you don't want to have to amend W-2s from the former year, do anything like that. So it's definitely important, if you are at all concerned about that, definitely speak to your Corporate Synergies account manager or your non-discrimination testing vendor or actuary to ensure that you're completing that test before the end of the calendar year. Then the third thing that we're seeing is a lot of questions about MLR rebates, and sometimes they're called COVID rebates, but really what these are MLR rebates, or medical loss ratio rebates, under certain ACA rules that basically said that for sponsors of fully insured plans, if the carrier providing that fully insured policy is getting too profitable, they have to give some of that money back to the participants. So why is this happening, right? Well, no one's going to the dentist anymore, right? No one, people aren't taking advantage of routine physical exams, things like that, getting routine treatments. They're putting treatments off because they're afraid of the pandemic and going to a medical facility and for other reasons. And so what that means is that the insurance carriers for the fully insured plans are more profitable than ever. And when they return that MLR rebate money to the plan sponsors and employers that sponsor those fully insured plans in the form of an MLR rebate, then to the extent that any of that money contains plan assets, which generally means employees paid for that portion of the premium that's now being returned by the carrier to the employer, that it must be returned to the participant who made those contributions to the best extent possible, generally speaking. And so we have an e-alert on this topic from June 12th that goes into more detail on what you should do and should not do with that money to avoid participant lawsuits and other plan liabilities. So definitely check that out as well. And let's talk about the exciting stuff for today, right? The pre-election stuff, right? That's I think what I think we should be talking about. And just to clarify something real quick, right? The insurance companies were giving out the medical loss ratio rebates early. So I actually just saw one of the questions come up is, I thought those were based on 2019, right? Well, 2019 shouldn't have had an impact, right, on the medical loss ratio. But what we're seeing is, and this is also discussed in that e-alert, is that that the carriers are paying this out early, right? They're allowed to pay the medical loss ratio rebates out early, maybe because there's just so much of that money they know they're going to have to pay back. And they also want participants to get the benefit of having that money back earlier as well. And so they're calling them sometimes COVID-19 rebates, or they're calling them COVID rebates, but they're in reality, they're just early or advanced medical loss ratio rebates. But if you have any questions about that, of course, we're happy to take a closer look at what the actual thing is that you're getting, because sometimes it may not actually technically be a COVID, may not technically be a MLR rebate rule. But I think regardless of what it's called, right, if the underlying principles are still the same, if it's plan assets because an employee contributed their money into that money, into those premiums, it's employee money paying for premiums that the carrier is now returning back to the employer, right? The employer has an ERISA fiduciary obligation to make sure that that money goes back to the participants as best as possible. So that's what we're talking about. Okay, so let's talk about the exciting stuff, the election that's coming up. And I know it's been in the news a lot. And so we wanted to talk a little bit about what this means, what these platforms mean for employers and plan sponsors out there. What are both of the candidates saying that could really have an impact on the health and welfare plans and insurance arrangements that your organization is sponsoring. So let's talk first about, we're going to talk about kind of generally speaking, how do these candidates each see the future of healthcare in this country, the future of the ACA, how they are planning to attack the COVID-19 pandemic and protect the healthcare of our citizens, but also what are they doing to lower healthcare costs? I think those are I guess you might call them the 3 or 4 main buckets that I'm going to be talking about as I kind of go through and describe some of the major policy initiatives and platforms of the candidates. So let's start with President Trump. The president's focused on reducing the high cost of healthcare. I think that's definitely one of his big pushes, and in particular, reducing prescription drug costs through the relaxing of drug importation rules. And his most favored nation policy is something that he often talks about, which generally speaking, it's a policy that seeks to ensure that that the U.S. doesn't pay more for U.S. produced prescription drugs than for what other countries pay. He's also focused on eliminating the high cost and regulatory complexity of the ACA and the entire ACA itself. In fact, he's submitted a brief. The Trump administration has submitted a brief in the case seeking to overturn the ACA, and the brief is in support of overturning the ACA in its entirety. And notably, that was not retracted during this pandemic. And more specifically, when it comes to the ACA, he is focused on eliminating or significantly limiting many of the ACA mandates. He often talks about how he's very proud that he was able to eliminate the individual mandate through tax reform, but also the contraceptive mandate. Essentially, there's very big carve-outs in that now. It's nothing like what it used to be. He's also because he's also sought to reduce a lot of the other ACA rules that add a lot of complexity, and including mental health parity rules. He's focused on eliminating the pre-existing condition protections of the ACA by eliminating that law in its entirety. But at the same time, he has said that he wants to still keep pre-existing conditions in place based on his recent executive order, which said that. But it is a little, it is causing some confusion, because on the one hand, he has not retracted the brief that is trying to overturn the entire ACA. And he has also released an executive order saying, he wants to keep pre-existing conditions, keep protections for pre-existing conditions. So what that's left some commentators thinking is that perhaps, he's already planning ahead. He's thinking that, he wants to make it clear that whatever new proposal he is going to be coming up with to replace the ACA, that it will include protections for pre-existing conditions. Or, I think on the more critical side, some are left thinking that, well, if, these pre-existing condition protections he's planning on doing they may be watered down protections, or protections with lots of exceptions in them, such as protections for COVID-19, pre-existing conditions like COVID-19 and related illnesses may be an exception to that. So there's a lot of concern, I think I would say, by by those that are critical of the president, that he is planning on carving out major holes in the ACA's protections for pre-existing conditions. The president is also focused on COVID-19 relief, and he signed several monumental stimulus relief laws into place, such as the FFCRA, which we talked about earlier. His approach has delegated the primary responsibility for COVID-19 to the states and to the governors of the states. And he has broadened Medicare coverage of telehealth during the COVID-19 pandemic and provided relief funds for healthcare providers in the fight against the pandemic. He is focused on also on limiting or capping when it comes to sort of, reducing healthcare costs. There's a number of other things that he's been doing. He's been focused on limiting or capping federal funding for Medicaid and limiting Medicaid eligibility. Yet at the same time during his term, he's also reduced insulin costs for some Medicare beneficiaries and proposed other ways to reduce drug prices and other healthcare costs for Medicare beneficiaries as a part of his more recently unveiled America First healthcare plan. So there's a lot of things he's doing to reduce costs. He's also he supports enhanced hospital price disclosure, including enhanced price disclosure on prescription drugs, as well as he supported prohibitions on surprise medical billing, and he's focused on alternatives to the traditional health insurance coverage, like MEC, minimum value, affordable coverage, by making it easier for individuals and companies to form into association health plans or AHPs, as well as individual coverage HRAs or ICRAs, and short-term limited duration insurance or STLDI, which is coverage that is meant for short-term purposes that does not need to meet all of those ACA requirements. So he's looking for a lot of lower cost alternatives out there that may not provide as good coverage, but that may reduce costs significantly. So that's big picture what his goals are. Let's look at Biden now for a minute. Biden is focused on continuing the ACA, but making tweaks to it to make it more comprehensive and to allow it to cover more people, and in particular, more lower income people and immigrants. He seeks to add to the ACA several new features, including a new public option, which will be available to low-income individuals, even if they're offered employer-sponsored coverage. It would be available to people who'd otherwise be eligible for Medicaid in the non-Medicaid expansion states. He would also enhance the subsidies on the exchanges. He is also proposing to increase the number of people eligible for subsidies on the exchanges. He's focused on protecting the ACA's current protections for pre-existing conditions. So he's ensured that there will not be any carve-outs or exceptions to those ACA rules for things like COVID-19 and COVID-19 related illnesses. He is also focused on enforcing the ACA's existing mental health laws and expanding the funding for mental health, and which is something that we're not really seeing. We're not seeing a lot of enforcement of those mental health parity laws currently. He is seeking to fight the COVID-19 pandemic through a federal response that will not be reliable on the states and their different state governors and their plans. He's focused on significant reforms to enhance, like Trump, he wants to enhance Medicare and Medicaid benefits, but he wants to lower costs for Medicare and Medicaid beneficiaries by a number of different measures. I think it's probably too much to talk about today, but among other things, he wants to lower Medicare eligibility to age 60, with an option for people ages 60 to 64 to keep their coverage. He's also focused on reducing drug prices under Medicare by direct government negotiation with drug manufacturers, and he seeks to cap out-of-pocket costs in Medicare Part D. So those are just some of the things he's proposed when it comes to the many ways that he would enhance Medicare and Medicaid. He also supports, like President Trump, he also supports prohibitions on surprise medical bills, and is focused on allowing increased importation of prescription drugs, but subject to safeguards. So what are the takeaways here, right? Those are kind of big picture summaries, right, of the major initiatives and healthcare policy goals of the two candidates. So I think really, if we're looking for the big takeaways here for employers and sponsors, I would say that Trump is certainly more of a proponent of giving employers more flexibility in easing regulatory and cost burdens. But at the same time, it's fair to say that his regulatory initiatives have not had as much success in the courts as those initiatives that were introduced during the Obama and Biden years. For example, Trump proposed rules on association health plans, the contraceptive coverage mandate, the elimination of anti-discrimination protections and rules applicable to federally subsidized health insurance coverage, and rules on COVID-19 related leave that have all been challenged, are currently being challenged, or that have actually been invalidated in whole or in part at some point. So a lot of his proposals and things that he's tried to do with healthcare have been challenged in the courts. But by contrast, Biden's proposals are not as likely, certainly not likely to significantly reduce costs or regulatory complexity for employers. I think it's also fair to say that at this point in time, it's many employers are probably already used to most of the requirements of the ACA. And they're prepared to handle a slightly tweaked version of the ACA, even if it means more of their employees are now going to be eligible for subsidies on the exchanges. I think I think a lot of the employers out there are probably okay with that. But we'll see. Additionally, for many Americans, the ACA's pre-existing condition provisions are very popular. They do not want to go back to the pre-ACA days where they could be denied coverage based on such pre-existing conditions or go bankrupt paying for an unexpected medical bill. And so even though the president has signed this executive order saying that he will protect those, it's not clear that will be the same as what the ACA currently protects. And so that's, I think, where there's a lot of concern. And while the Obama Biden healthcare proposals definitely had more success in the courts than President Trump has had with his regulatory proposals. If you can remember back to the Obama years, right, there were also several very unpopular provisions of the ACA from the employer perspective, at least, that really never saw the light of day during those Obama-Biden years. And it's likely that many employers out there and plan sponsors don't want to see any of those things come back. I can think of two examples. I think they're really, many of you out there may remember. One was the mandatory non-discrimination testing for fully insured medical plans. Another was those opt-out rules that were extremely complicated. Neither of those rules ever really saw the light of day. Under the Obama years, they were just kind of never finalized, but they were not finalized during the Trump administration. And we may see those things return. It's unclear. They're not a major part of the policy initiatives outlined by Biden, but you never know. I mean, there may be people in that are eager to see those come back. So looking at all of this together, right, there's certainly a lot of pros and cons, to each side from the employer and plan sponsor perspective. There's quite a lot of similarities as well. Both candidates are focused on reducing prescription drug costs, right, enhancing the flexibility and the funding of benefits for Medicare beneficiaries. They're both focused on enhancing disclosure of hospital and prescription drug prices. They want to see, they both are focused on creating new prohibitions to reduce surprise medical bills. So there's a lot of similarity there as well. So a lot to think about as we head into the election season. So that's it for today. I just really want to thank you for joining us, and I hope that this program was helpful in adding perspective to what's impacting your organization's plans right now, and really how voting can really have such a big impact on how your plans operate. And I think before we get into questions, I also wanted to briefly put in a plug for our next pre-election webinar. It's an event that's coming up on October 21st. A healthcare policy panel, which will be a discussion with the CIAB's Joel Wood and Joel Copperwood, who are two of the insurance industry's leading lobbyists. They've presented with us in the past and have just really provided an incredibly deep, incredibly deep insight into what where the law is heading, from each side of the political spectrum. And these are just real insiders. They speak with senators and other lawmakers on a daily basis. And, they're right there in the middle of everything in DC, where the regulatory sausage is being made, and just have a really interesting perspective. And during that event, we're going to go into even more depth about what is likely to happen with this election and where it's likely to take your benefit plans and insurance arrangements going forward. So definitely don't miss that one coming up. And that's it. Let's see if we have, Dot, do we have any questions out there? Let's see here.
Nope, currently none, not as of yet.
Okay, great. Well, look, we're still happy if you could definitely, if you're a client of Corporate Synergies, definitely reach out to us, and we'd be happy to answer them, or just reach out anyway. But thank you so much and for joining us today. Have a great day and enjoy those debates tonight. Thanks.